get started. We are going to talk about the February 2024 bar exam tonight. But first, let me introduce myself. I think I've met a lot of you that are here. If not, welcome. My name is Maureen. I am the founder and creator of BarMD. We are a full service bar prep company for the UBE, for California, for a lot of jurisdictions that also don't necessarily do the UBE. We have books that we have released. I've written books on the MEE, on the MBE, finishing up my MPT book. Been saying that for a little while, but it is just about to launch. And we have courses. We have workshop courses for the essays. We have workshop courses for the performance test, etc. We have everything you could possibly need. So just throwing that out there. I'll talk about this stuff in a little bit too. And you're also going to get something because you're here tonight. So I'll get to that towards the end of the class. All right. So first, we want to start going through the February 2024 UBE, and I am going to place a link in the chat for you to grab the essays that were administered for the February 2024 exam. If you click on this link that I just posted in the chat, you click on that link, you should be able to access the page where the questions are located. So I'll give everybody a minute to get that up and we will get going. So first, I just want to go over the objectives for today. We're going to talk about the February 2024 bar exam, but I want to just talk about a couple of resources for those of you prepping. I do have, this just came out, the best essay book, the UBE edition. It's $149. It contains everything you need to know how to pass any bar exam essay the bar examiners might throw at you. So it's templates for addressing just about any issue you might get, not every single thing, but really like knowing where you need to focus in your analysis. Knowing where you need to focus in on your analysis, I actually write the analysis, you fill in the blank. So the way you use this book, and you're going to get a sample of it for joining today. We're gonna email you out one of the full chapters that I wrote. So what you can do is for anytime you write an essay, for just about every essay, if you go and find that issue in the book, you look and compare your organization of how you did it, your rules, your analysis, was it in depth enough? And you compare that to the template that's in the book to see if you missed anything. So it's really designed as a way to check, to sort of give you almost a model answer for any issue. There's a bunch of time-saving tips. My rules that I write tend to be more simple, and there's fill-in-the-blank analysis for it. So just throwing that out there. We also have, for those of you that have taken the bar exam previously, our MBE course is, it's all recorded. And we have a class that covers every single MBE subject. It is not too late to join. It's $299. It's normally $499, but it's on special right now. And I can give you all the link if you want to check that out as well. For those of you that are struggling, it's really designed to give you lots and lots of tips for the MBE portion. We walk you through a bunch of questions. You get 200 MBE questions in here. So I'll put the link to that right now if you want to check that out. So it's these 8 classes. And if you're having a hard time with the MBE, this is really, really good. I always try to focus on tips that you won't see other places. I've gone through and I have dissected every single MBE question that there is. I know the MBE inside and out. I wrote a book on it. I wrote a book for the MBEs. And then because I wrote that, I was like, all right, we can take this and really put it into a really thorough course. And people love that class. It's definitely a favorite. That is going on. It's recorded. And then we obviously have our Mastering the Essays classes and our Mastering the PT. So just throwing it out there. So especially as we walk through these essays today, if you struggled with it at all, if you felt like, if you're struggling writing essays, you struggle with the organization, with issue spotting, anything at all, we cover how to do that for every subject on the MEE. We have 2 versions of it. We have one where you can join live, ask questions. We show you how to write the analysis, how to write counter arguments, etc. You can join live or you can watch it recorded. And we also have this for the PT. I will be doing a PT workshop for free in a couple of weeks. So keep your eyes out for that too. So definitely look out for that. But this PT course is so thorough. There's definitely time for you to still join that class. If you had a hard time with the PT, And if that's something you generally have a tough time with. Yvette, I'm not sure what you're referring to in the book, or in the book. The book has, I have gone through the 2020. It doesn't include every single one, but I'm updating it as well. It's not similar. So we also have, somebody asked if the courses are similar to the bar essay checkup classes. No. So bar essay checkups, oh, the MBE, yes, Yvette, it does. Yes. The bar essay checkup classes, this is a new thing that I'm offering for those of you that aren't aware of it. I introduced this thing on Sunday where there's these bar essay checkup sessions. And what we do is I give you the materials. So you're going to get either 6 MEEs or 2 PTs. And I'm time you, so it's proctored. You go, you write the essays, you write the PTs, and then I am going to walk you through them, walk you through what you needed to do. I answer questions, etc. So it's designed to get you practicing, simulate the exam environment, and really kind of like get that heightened stress level. But these classes are much more in depth. It's the classes are instruction. We're walking you through how to write. We're walking you through issue spotting. And you get access to the archive of all of the prior essays that we have taught. So if you want to be able to have access to essays and realistic model answers that we have written, that's in the essays course. So they're definitely different. The bar essay checkups are different from, they're designed to really supplement the essay course. So the essay course, we do all of the teaching to really walk you through how to write strong essays, like step by step. How do you put it together? How do you go from, if you're in a jurisdiction that does a 1 to 6 scale, getting a 3 to a 4 to a 5. You're in New York, how do you cross from like a 40 to above a 50? So we walk you through all of that in these classes. Same on the PT, we walk you through step by step. So I'm a really, really big believer in teaching people how to do something, not just saying, all right, here's a bunch of information, go. I want to show you what things should look like, how you get there. And also, I don't want to just, I remember when I took BarMD, when I was, after I graduated law school, I was frustrated that I just had all these perfect answers. And I wanted to see if it was something that was realistic, because that felt so unattainable and I was really frustrated. So that's why we have these classes. That's why I started doing bar prep, because I really strongly was frustrated with all of that. All right. And I'll give you a link to these classes as well. We have, I'll put the link to, and also for all of the classes, you can split it up into 2 payments. So we make it really, really easy for you to split it up, to make it just a little bit easier. So here's the class for the PT, and here is the class for the MEE. And there are live versions, and there's a version to watch it recorded, and you can save a little bit of money that way too if you can't join live, or if you'd rather just be able to watch it on your own time. All right, so let's talk about how bar graders grade. They just spend 2 to 3 minutes on each essay. That is it. They don't dig into your material to look at whether you've done it correctly. They're not going back and rereading it 2 or 3 times to really try to give you those points. I've been a law school professor. I did that for a number of years before I started doing this full time. And when I was a professor, I would always really want to give my students the benefit of the doubt. I would spend time. I would always start by doing a skim and read through all the essays to get a sense of what was going on, of what people got, what they didn't get. And then I would go through and read closely and spend quite a bit of time, and I was commenting and giving feedback and all of that. Bar graders don't do that. They spend just a couple minutes, 2 minutes if you're lucky. They look for keywords. They look for thorough analysis. One of the big tips, and we go way into this in the essay class, is using more facts. How do you use more facts to really increase and deepen your analysis, to go from having just a passing score or below passing to passing? Bar graders don't look twice. We teach you this in the essay class. How do you make things explicit for the examiners? For the graders, make it very explicit, make it easy for them to give you points. That's what we want. And that's what we like to show you in our classes. How do you do those things? How? Because that's the biggest question people always ask me. All right, well, how do I do that? Right? Instead of just, look at my answer and you figure it out, right? Which is what a lot of law school was like, I would imagine. Is that how you guys felt in law school? For the most part, your professors would tell you stuff, and then you're, told to write an essay. All right, well, how do I do it that way? And it's frustrating, right? That's how this is different, is we definitely show you how. All right, so let's get into these essays. So I am going to pull them up again. I think I gave you the link to the essays. We're going to read through them, and then I'm going to walk you through the analysis as well. So y'all should be able to see on my screen. It says February 2024 MEE question 1, agency and partnership. In February, Wendy opened Kibble, a store selling dog food made from organic ingredients, as well as dog toys and dog grooming products. Wendy operated Kibble as a sole proprietorship, so she's solo. Kibble soon ran into financial difficulties, and Wendy could not pay its bills. In early April, Wendy asked her friends, Mary and Angelo, for financial assistance. On May 1st, in response to Wendy's request, Mary delivered to Wendy a check payable to Kibble. In exchange for this contribution, Wendy agreed in signed writing to pay Mary 15% of Kibble's monthly profits for as long as Kibble remained in business. So this looks like they are 2 or more persons now carrying on as co-owners of a business for profit, right? Which is just creating a partnership, and this would be a general partnership given doesn't look like any of the formalities to create a limited partnership are present so far anyhow. Mary also agreed that if Kibble suffered losses, she would share 15% of those losses with Wendy. This also makes it look like a general partnership as well, sharing profits, sharing losses. As part of their deal, Mary began working at the store with Wendy and helped Wendy with business planning for Kibble. So they're really working together. They're really, really working together here. So it looks like Mary and Wendy are now general partners. On May 2nd, also in response to Wendy's request, Angelo delivered to Wendy a check payable to Kibble. On the memo line of this check, Angelo wrote loan to Kibble. So it's got to be repaid, right? And when I see a loan, I'm immediately thinking this is a creditor. This is a creditor and they owe a debt. Angelo agreed in a signed writing to accept 15% of the monthly profits of Kibble as repayment of the loan until the total loan amount, including interest, was repaid. So this looks like Angelo is a creditor, right? Because he's just wanting to get his loan repaid back. Doesn't look like he's working or doing anything, which is different from Mary. Yeah, and somebody mentioned in the chat, this is identical to July 2010 UBE. Yeah, they do this a lot where they sort of recycle fact patterns. It happens all the time. Beginning in June, Wendy paid 15% of Kibble's previous month's profits to Mary and another 15% to Angelo. On October 1st, Mary wrote a letter to her son, Bob, stating that she was assigning to Bob as a gift all her interest in Kibble effective immediately. So she can do that. You can assign your benefits to somebody else. But that just means that Bob is an assignee. It doesn't mean anything else for Bob. It doesn't make Bob a general partner just by doing that. He's just an assignee that has an interest. Later that day, Mary handed a copy of that letter to Wendy, who immediately read it and said to Mary, I don't want Bob involved with Kibble. Fine, he's not really going to be. Mary continued to be active in the business operations of Kibble. Early in November, Wendy distributed to the appropriate October profits of Kibble to Mary and Angelo, but distributed nothing to Bob. Okay, so she's supposed to, right, if she had any profits. On November 10th, Bob demanded that Wendy distribute Mary's share of Kibble's profits to him and that she also allow him to inspect the books and records of Kibble. Well, there's a question here. Is Bob entitled to inspect the records? Bob can get the profits because there's a valid assignment, but can he inspect the books? On November 15th, Mary learned that Wendy was using Kibble's delivery van on Sundays to transport her nieces to their softball games. Can't do that. I think there's an old fact pattern like this with the flower shop is what it was. So basically the same fact pattern, but change the facts slightly. Mary demanded that Wendy stop doing so, but Wendy refused. You can't use partnership property for personal things. Noting that the van was not being used for Kibble's business on Sundays. It doesn't matter. It can sit there unused. It's for the partnership, not for the partner. So what legal relationships have the parties established through their dealings? Remember, you've got to address both Mary and Angelo. Is Bob entitled to Mary's share of the monthly profits? Is Bob entitled to inspect the books and records? And is Wendy entitled to use the delivery van on Sundays? All right, so let's walk through this. So what legal relationships have the parties established through their dealings? Wendy and Mary are general partners. All those facts tell us that there was a 15%. They're going to share in the profit in perpetuity. They're also sharing in the losses. And Mary is also now working at Kibble. And Angelo is a creditor, not a partner, because Angelo was expecting to be paid back. He's only getting paid a part of the profits until his loan is paid in full with interest. So is Bob entitled to Mary's share of the monthly profits? Yeah, Mary can transfer her interest in her profits and losses because she's a partner. And Mary did transfer her rights to receive profits to Bob when she transferred her interest to him. So your rights are absolutely transferable, but that's just your rights to your benefits. You don't transfer your rights of like what you're doing, your duties as a partner. Is Bob entitled to inspect the books and records? So partners are entitled to inspect the books and records. Bob is not a partner, so no, Bob does not get to inspect the books and records. That is limited. This is a fairly common question that's asked as well. I've seen this come up a number of times on the MEEs. And is Wendy entitled to use a delivery van on Sundays to take her nieces to their softball games? No. The van is partnership property. It was acquired in the name of the partnership, and it cannot be used for personal purposes. So no, Wendy is not entitled to use a delivery van. Any questions? I thought this one was pretty straightforward. This is pretty straightforward, pretty just cut and dry agency partnership issues. They walk you through the questions, and there weren't really any big surprises here. There was some essays I thought that were tougher. So an example of how, just getting to the point, an example of how of all of the facts that I could use. So you might just say that Wendy and Mary were partners. They became partners because Wendy agreed in a signed writing to pay Mary 15% of Kibble's monthly profits for so long as Kibble remained in business. It's really because of that, for as long as Kibble remained in business. That's what I would place emphasis on. And, you could just end there and you'd be okay, that's fine. But to really beef that answer up, add your additional facts. So she would also share with 15% of those losses, right? General partners generally share in profits and they share in losses. So explaining the significance of this particular fact. Also, it also looks like Mary is a general partner because Mary began working at the store with Wendy and helped Wendy with business planning. This is something that people that are carrying on a business as co-owners for a profit would do. So really kind of using as many facts as possible, just like I did there, to really beef up your answer. But you also have to know how to balance that out. I don't want you to just write a really beefed up answer to call number 1 and run out of time for call number 4, or have that trickle down throughout and then you're not answering question 6. We want to avoid that completely. So that's something else that we really focus on in the class is time management. How do you make it so that you don't run out of time on these essays and you can actually finish? So it's a huge, huge skill. It takes a lot of practice. So that's something we really like to show you how to do. And it's fine. Somebody said that they included Bob in number 1. No, it's not wrong to do it. You could just say that Bob is not a partner also. Yeah, you could definitely, I see why you would address Bob. You didn't need to, but you could. All right, question number 2 is contracts. Let me actually start down here with the questions. So has grandson breached an express warranty? Explain. And does buyer have the right to rescind or avoid the contract on the basis of a mutual mistake of fact? So they're really giving you the issues here. It's pretty narrow. You want, in order to know if they've breached an express warranty, we want to know, have they made an express warranty? So we're going to look for that language. And then whenever I think of right to rescind or avoid a contract, so I'm thinking of a mutual mistake of fact. So has there been a mutual mistake of fact? Remember that for a mutual mistake of fact, it has to be something where the mistake is about a basic assumption upon which the contract was made, and the mistaken party did not assume the risk of the mistake. So we're going to break these down a little bit. I'm going to break these down. So let's read through this. A wealthy art collector recently died, leaving her entire collection of artworks to grandson. After receiving the artworks from the estate, grandson, who did not share his grandmother's interest in art, decided to sell them. With the help of art appraisal experts, he prepared a catalog describing each of the artworks that he hoped to sell. So he's working with art appraisal experts. The catalog, a copy of which was given to each person who expressed interest in buying any of the artworks, identified one painting as an early work by Artiste, a prominent American artist who died in 1956 at the age of 78. Buyer, an art collector who loves the work of Artiste, read the catalog and was intrigued by the possibility of acquiring the painting described as one of Artiste's early works, so he asked to see it in person. Grandson allowed buyer to examine the painting only visually for up to 30 minutes. So only allowed to look at it visually and only allowed for up to 30 minutes. And also here, I want to point out, we're asking about, is there a breach of an express warranty? This has been identified as a painting as an early work by artiste. Saying that it is by someone is warranting that it is by them. This might look a little different from what we are used to seeing. Like, I warrant that this is spill proof. I warrant that this is, that there is no defects, right? This looks a little bit different maybe from what you're used to seeing, but thinking about it in the context of the question, there is an express warranty that this is by artiste. I also note too that grandson looks like he's genuinely believing that this is by artiste because he was helped by art appraisal experts. So buyer visually examined the painting for 30 minutes. Okay, so visually examined it. Buyer is an art collector who loves the work of artists, so probably is familiar with their work. Did not notice anything that caused him to doubt that the painting was a genuine artiste. Buyer then told grandson he'd be willing to pay $350,000 for the artiste painting. So it in quotes here, that he believes that this is a painting by artiste. Grandson agreed to that price. Grandson and buyer then executed an art purchase agreement prepared by grandson's lawyer. The art purchase agreement identified the item being sold as a painting by artiste. So again, this is probably going to be an express warranty. It's in the contract. It says that the item is a painting by artiste. And stated the price is $350,000. The art purchase agreement also contained a number of conspicuous provisions labeled terms and conditions of sale. One of those provisions stated that seller disclaims all warranties, express or implied. So whenever you have a disclaimer of warranties like this maybe threw some of you off if you took this exam. Whenever you have a disclaimer of warranties and there is an express warranty given, they have to be read, they have to be congruent. So if you give an express warranty, you generally can't then turn around and disclaim it. So the warranty here that it was a painting by artiste will still be valid despite the disclaimer. Shortly after buyer and grandson executed the art purchase agreement, buyer electronically transferred $350,000 to grandson's bank account, and grandson delivered the painting to buyer. 3 weeks later, buyer read a news article reporting that several counterfeits of artiste paintings had recently been sold. The article reported that these counterfeit paintings were of such high quality that mere visual inspection could not detect the counterfeiting. That's all that was allowed. Wasn't allowed to do any more, and only a chemical analysis could do so. So when I'm thinking about assumption of risk, did you know that you were acting with limited information and proceed anyways? Not really, because he did do a visual inspection. He seems like he has knowledge because he is an art collector who's familiar with the work of artiste, who loves the work of artiste. So I'm assuming familiarity. And it's generally not going to be available that somebody's going to be able to do a chemical analysis, maybe. Buyer consulted a professor of art history who arranged for a chemical analysis of the paints used in the painting bought from grandson. So it's possible, right? But maybe not something you would generally do. Or maybe not generally accessible to just anybody. The analysis revealed that the painting was not the work of artiste. Because it was not an authentic artiste painting, it was worth only $500. Buyer has sued grandson, seeking either to recover damages on the theory that grandson breached an express warranty that the painting was the work of artiste, or alternatively, to rescind or avoid the purchase of the contract on the basis of a mutual mistake of fact. Each party had stipulated that the other believed in good faith that the painting was a genuine work of artiste. So we know that there is a mutual mistake here, right? We know that there was a mutual mistake. That's fine. We don't have to actually go in and establish that, which is nice. So what really looks like with the mistake issue is, did the buyer assume the risk of the mistake? And was the mistake one that goes to a basic assumption upon which the contract is made? So has grandson breached an express warranty? So number one, UCC governs, right? We always, in contract, we always want to ask ourselves what body of law UCC, because it's for a painting is a good. So the statement that the work was by artiste, that absolutely is an express warranty. I would point to these multiple facts, said that identified one painting as an early work by artiste, the fact that the contract says the painting is by artiste. Warranty was breached because the painting is not by artiste, right? But it turns out later that they said that it was a counterfeit, that the paintings were of such high quality. Yeah. So really, we just have to show that the painting was not by artiste and address that the disclaimer is ineffective because it's incongruent with the express warranty. So an express warranty, if there is one, or if there's any sort of disclaimer, it has to be read, to make, any express warranty jive. So any other implied warranties are fine. Those are disclaimed, but this express warranty is not. So grandson has breached an express warranty. Absolutely. So buyer is going to be able to recover the damages, but they told you not to worry about remedies. So we're not going to address the remedies. So check, did you address the remedies? If you have your essays, you should look at that. Make sure that you're following instructions and not overdoing it. So then does buyer have a right to rescind or avoid the contract on the basis of mutual mistake? So both parties believe the painting had been painted by artiste. They thought, and that the painting was painted by artiste was a basic assumption upon which the contract was made, because that's the only reason he was buying it. It's the reason it was selling for $350,000. It's the reason buyer was buying it. And buyer didn't assume the risk of the mistake because he did inspect the painting visually. He also spent the full 30 minutes inspecting it. You could only discover that the painting was not by artiste by chemical analysis, which was not allowed per the requirements of the grandson. Said you could only inspect it visually for up to 30 minutes. And buyer's also relying on an express warranty by the seller, by grandson. So given all of that, it does not appear that buyer assumed the risk of the mistake. So buyer can rescind the contract on the basis of mutual mistake. I thought this one was also fairly straightforward. You know, they do break the issues out nicely for you. I think what's important to see here is that you want to address multiple issues within these. So under as grandson breached, what law applies? Has an express warranty been made, and has it been breached? There's really sort of three little issues in there. Does buyer have the right to rescind? You have to establish that there's been a mutual mistake. That's established in the facts. That the mistake is one was a that it was painted by artiste. That the mistake is about a basic assumption upon which the contract was made, and that the buyer did not assume the risk. So you have to make sure you address all of those little issues and using as many facts as you can while still maintaining your 30-minute time. All right, let's go on to question number 3. So this was evidence. This one was evidence. Evidence is always a racehorse. And I think this one's a little bit tougher because it deals with issues that people don't really love. Let's look at the call to question. So did the trial court err by denying Dana an opportunity to be heard before it took judicial notice of the weather on October 18th? And it's just about an opportunity to be heard on the issue. So it's pretty specific here. Assuming that the trial court did not err by denying Dana an opportunity to be heard, did the trial court err by taking judicial notice of the weather on October 18th? Was Dana's testimony that Kara was careless, inadmissible character evidence? I don't know about you guys, but when I see character, even though like I know it inside and out, I still don't like it. I've taught evidence. I still don't like dealing with character. There's just so many complexities and wrinkles to it. Worse on the MBE, but I see it in an essay and I'm just like, ugh. So, but we have character here. Was Dana's testimony that Kara often misplaced or forgot her cell phone inadmissible character evidence? Explain. All right, let's look at the fact pattern. So, Kara filed a civil suit against Dana, her former coworker, alleging that Dana had stolen Kara's cell phone from her locker at a gym. The jurisdiction has adopted rules of evidence that are identical to the federal rules. At trial, Kara testified during a case in chief stating, on October 18th, I worked out at the gym. After I completed my workout, I returned to the locker room to change clothes and retrieve my belongings from my assigned locker number 344. My locker number 344 was near the entry door to the locker room, and when I walked into the locker room, I saw Dana hurriedly closing the door to my locker. I am positive it was Dana because it was cold and rainy that day, and Dana was wearing a heavy, bright orange coat. I had seen Dana wearing that coat several times before at work in the gym. When I got to my locker, my cell phone was not there. Dana also testified during her case in chief stating, I definitely worked out at the gym on October 18th because I was training for a marathon. I don't recall seeing Kara at the gym that day. For several reasons, I am also positive that I was not wearing a heavy, bright orange coat. First, I ran on the outdoor track that day because the weather was overcast but not cold and rainy. Second, as I always do for my track workouts, I ran in shorts and a t-shirt. I never wear a coat or jacket while running on the track. Third, I never take my coat or jacket into the gym. I always leave it in my car so it doesn't take up space in my locker. Dana also testified as follows. I'm not surprised that Kara lost her cell phone at the gym. She's pretty careless. At work, she often misplaced it or forgot it in the conference room after meeting or in the break room after lunch. Kara objected to this testimony, asserting that it constituted inadmissible character evidence. The judge overruled the objection. During her rebuttal case, Kara asked the court to take judicial notice of the weather on October 18th based on a certified public record from the federal government's National Weather Service agency. So that's something you can generally properly take judicial notice of. The record was a weather report for October 18th in the area where the gym was located, and at the time Kara testified she was at the gym. According to the record, on October 18th, it had rained all day and the high temperature was 41 degrees Fahrenheit, 5 degrees Celsius in the area of the gym. Dana objected to Kara's request and asked for the opportunity to present an argument that taking judicial notice would be improper. The court immediately overruled Dana's objection and denied her request to be heard. Usually you've got to be heard. The court took judicial notice of the weather as detailed in the public record. All right, so did the trial court err by denying Dana an opportunity to be heard before it took judicial notice of the weather on October 18th? Yeah. Rule 201 requires a court to hold a hearing after a defendant argues against taking judicial notice. You have to have a hearing. So when the court immediately overruled Dana's objection without a hearing, the court absolutely erred. Pretty straightforward, but you have to know this rule. So this is one of those ones where this is why going through and doing as many MEEs as humanly possible and seeing all of the issues is so important. So assuming the trial court did not err, even though they did, by denying Dana an opportunity to be heard, did the trial court err by taking judicial notice of the weather on October 18th? So you can take notice of certain facts, adjudicated facts, legislative facts, but an adjudicated fact is a fact that can be readily determined from sources whose accuracy cannot reasonably be questioned. Kara provided the National Weather Service report. The facts are not reasonably in dispute about what is in this report. And the reason for that is because it's a certified public record from the federal government's National Weather Service agency. That's pretty reliable information, pretty reliable. Was Dana's testimony that Kara was careless inadmissible character evidence? So character evidence is evidence that's offered to prove action and conformity therewith. It said, because you did this in the past, you did it on this occasion. That is generally not allowed unless we have one of those unique cases such as like sexual assault, child abuse, stuff like that. That's where it's allowed. So you cannot do that. Character can be admissible in a criminal case or in a civil case to impeach the truthfulness of a testifying witness. But this is a civil suit for theft, and the testimony does not impeach Kara's character for truthfulness. So saying that she's careless isn't getting at her credibility. It's just trying to say that she's been careless before because she leaves her phone around. She always leaves it all over the place. So she must have been careless that day and she just didn't, it wasn't actually there. She lost it. The next issue is, I think, a bit trickier. So with Dana's testimony that Kara often misplaced or forgot her cell phone, inadmissible character evidence. So Dana might have offered this for a non-character purpose, and she's offering to prove that no theft occurred, right? Not to prove that she often misplaced or forgot her cell phone, right? So there's a slight difference there, but it's actually still impermissible character evidence because you're actually still proving character. The fact that C loses and misplaces her phone a lot, and hence she must have on this occasion at the gym. So I think this is one of the trickier issues. Something to watch out for too, like this is an evidence essay. Often in so many evidence essays, you want to talk about relevance and all of that as well. We see that a ton. Here, you didn't really have to do that. They asked you the questions, you didn't need to dig into relevance. Sometimes when the questions are a little bit broader, you will do that. But here, you really just want to get in and like just get to the heart of the issue that they're asking you. All right, y'all ready to move on to essay number 4? Everybody hanging in there? You doing all right? Are you noticing things from when you took this exam? Noticing things that you missed? Noticing things that, maybe you didn't know the rule? Somebody asked, what about habit? There's not habit. Habit is something that is done. It's a routine response that you have where it's like without thinking, but this is too specific to be habit. All right, let's look at, did I say 5? Question 4. All right, so we have real property here. We've got real property. So I always start by reading the call to questions. So 1A, I just split this into 1, 2, 3, 4, by the way. My numbering is slightly off. It's just easier. If a court were to hold that Tom could have rightfully terminated the lease because Helen held over on January 1st, what rule would the court apply and what would be the rationale for that rule? So why would someone be able to terminate a lease because of a holdover? So why would that be the case? That would be the case if you show up and there's another tenant there already. So that means the landlord is not delivering actual possession. So this is known as the English rule. This is the majority rule. So if a court were to hold that Tom could not have rightfully terminated the lease because Helen held over, what rule would the court apply and what would be the rationale for that rule? So this is kind of a funny question. I thought the phrasing of this was definitely a bit different. I thought that this was definitely a little bit different. It's not often that they say, well, what's the rule and what's the rationale for the rule? But here you just have to kind of think about it. As long as you do know that there is this sort of split of delivering actual possession versus constructive possession and what's the rationale, then you're okay. So we'll get into that in a minute. Did the landlord rightfully refuse to consent to Tom's proposed assignment of the lease to his friend? Explain. And refusing to consent to a lease, that's generally okay. Like traditionally, that's okay. But modernly, courts say that it has to be reasonable. You want to evaluate whether it's reasonable. One little tip for everybody: whenever a rule has a reasonableness component to it, we want to analyze. There's often an opportunity for counter argument. So if there's a reasonableness component, if there is a foreseeability component. So always be on the lookout for those things. Following Tom's failure to vacate the apartment, could the landlord, so now Tom is a holdover, it looks like. Could the landlord rightfully treat Tom as a periodic tenant subject to the provisions of the expired lease? Explain. All right, let's walk through this fact pattern. On November 1st, 2020, a landlord leased an apartment to Tom for $1,300 per month based on a signed written term of years lease for a 3-year term to begin on January 1st, 2021 and end on December 31st, 2023. So they're telling you it's a term of years. You don't need to analyze that. The lease provided that Tom could neither assign nor sublet the apartment without the landlord's prior written consent. These types of provisions are totally enforceable. It's fine. But as I said, with the consent, traditionally, they didn't have to, really whatever they said was fine. But modernly, courts have applied a reasonableness requirement. The lease included no provision stating what would happen if Tom remained in possession beyond the term. On January 1st, 2021, Tom attempted to move into the apartment, but could not do so because the prior tenant, Helen, whose lease term had ended on December 31st, 2020, still occupied the apartment. Tom immediately notified the landlord that Helen remained in possession. The landlord responded, "I will get rid of her as soon as possible." Tom then booked a hotel room expecting he would be able to move into the apartment within the next few days. On January 4th, the landlord told Tom, "The apartment's now vacant, so you can move in immediately. Also, I will reduce the February rent by $100 for your inconvenience." Tom promptly moved into the apartment. About 1 year later, in January 2022, Tom found a house that he wanted to rent and told the landlord that he wanted to assign his apartment lease to a friend. The landlord conducted a background check on the friend and learned that the friend had a very low credit rating. This is a basis not to allow someone to be the tenant. The landlord told Tom that she would not consent to Tom's proposed assignment. Tom said okay, and he continued living in the apartment. On January 1st, 2024, the day after the lease termination date, Tom was still in possession of the apartment. On January 4th, the landlord sent Tom a letter telling him that she was treating him as a periodic tenant subject to all the terms of their original lease, including the monthly rent of $1,300, which substantially exceeded the then current market rate for comparable units. Tom wrote back, "That's unfair. I should have to pay only the current market value. I have remained in the apartment only a few days beyond the lease termination date." The landlord rejected Tom's suggestion and told him that as a periodic tenant, he would be liable for rent at the rate of $1,300 for each month of the periodic tenancy. That's all true. Landlords are right here, sadly. No statute or local ordinance affects either party's position on any issue. All right, so let's dig into this. So real property, and I put these questions on the next page, forgot to delete them. So if a court were to hold that Tom could have rightfully terminated the lease because Helen held over on January 1st, what rule would the court apply and what would be the rationale for that rule? So this is a so-called English rule, and under that, the landlord has to deliver actual possession. Constructive possession where you're legally entitled is insufficient. So the rationale is that each tenant, like when you move, you're expected to be able to reside on the premises. So failing to provide that is a breach. So kind of a funny question knowing the rationale. I would imagine a lot of people were making this up on the actual exam. So if that sounds like you made it up, or if you were like, "Oh my God, yeah," like how many of you, tell me in the chat, how many of you were just like, "Yeah, I didn't know what to do here"? Because that would have probably thrown me off when I studied for the bar. That's amazing. A lot of people actually got it. So if a court were to hold that Tom could not have rightfully terminated, so same thing, if you can't rightfully terminate, what's the rule? So this is the American rule. So constructive possession is sufficient where the tenant has the right to possess. So legally they have a right to enter, but actual possession is not required. And the rationale is that it's not the landlord's fault if the prior tenant's a holdover, and both the new tenant that has a right to be there and the landlord are essentially on equal footing to get that other tenant out. So that's the rationale, which seems a little crazy to me. I'm like, how am I on equal footing as compared to the landlord? right? Like, but they are. Let's talk about the third and fourth issues. So, did the landlord rightfully refuse to consent to Tom's proposed assignment of the lease to his friend? So, landlords may restrict the right to assign and sublet. Traditionally, a landlord could refuse to consent to a lease for any reason. You can refuse to consent to an assignment or sublease for any reason. So, under that rule, the landlord would have right to refuse to consent if the court takes the traditional approach. So this is also where you can get some extra points, as you're like, all right, under the traditional rule of this, and then bring up the modern rule. Addressing a jurisdictional split like this will help you. But modernly, many courts impose a reasonableness standard. So here, the landlord is aware of circumstances that demonstrated the friend may not pay rent in a timely manner due to the tenant's low credit rating. So because of that, landlord rightfully refused to consent to Tom's proposed assignment. So did landlord rightfully refuse? If you're under the traditional rule, no. Or under the traditional rule, yes. And even under the modern rule, yes, because he had a valid basis for it. All right, last call for the property essay. So following Tom's failure to vacate the apartment, could the landlord rightfully treat Tom as a periodic tenant subject to the provisions of the expired lease? Yeah, they had a term of years lease. It ended on December 31st. Tom stayed in possession longer than that date, so Tom's now a holdover. And a landlord can treat a holdover as a periodic tenant. And as such, the landlord here could treat Tom as a periodic tenant subject to the terms of the lease. It cut it off there. So yes. All right, let's do essay number 5. Criminal law and procedure. Okay, this is the all double jeopardy essay. How many of you got this? I do a ton of tutoring for the MBE, and people tell me in the chat if this threw you off. I'm surprised some of these people are saying this was my best essay, or they did all right, which is good. Sometimes when you see an issue and a lot of people don't know it, or if it makes you panic, then all you have to do is kind of stay calm and know what to do. And this topic is tested on the MBE a lot. And yeah, somebody said they were confident about it till they weren't. Yeah, that makes sense. Because this is testing all the little nuances of double jeopardy. So let's look at this. Start with the call to question. Is a state B hate crime prosecution barred by double jeopardy? Is the federal hate crime prosecution barred by double jeopardy? Is a state A hate crime prosecution barred by double jeopardy? And is a state A assault barred by double jeopardy? So city is located in state A, adjacent to the border with state B. So one thing that I just want to say, generally speaking, with double jeopardy is, and it's a rule that not a lot of people know. It doesn't come up a lot in the essays. I don't know that I've ever actually seen it in an essay, but the different sovereigns can prosecute you for the same crime. So if it's a different sovereign, if it's charged in one state, another state can charge you as well. If it's charged in a state, you can also charge it federally. So it's like the sovereignty rule with double jeopardy. So that's one thing. And then we have is it the same element issue? Is it the same element issue? Or does it have all of the same elements? So we want to look at that as well. All right, so city is located in state A, adjacent to the border with state B. One evening, a city police officer stopped a driver. The next day, the driver posted a social media video alleging the following. Late last night, a city police officer stopped my car in city near the state border, supposedly for speeding, and ordered me to get out of the car. The officer made disparaging remarks about a religious sticker on the bumper of my car and ridiculed my religious beliefs. He picked up a rock, threatened me, and asked how fast I could run. I ran about 50 feet and turned to see if he was chasing me. He wasn't, but he threw the rock at me and it struck me in the face. He laughed and shouted, "Look where you are. There's nothing you can do about it." This is horrifying. I saw that I was standing in state B and the officer was still standing in state A. So you can prosecute in both. My lip is busted and swollen. I had to get stitches. I want justice. The officer was charged with committing various crimes. So city criminal charge. A city ordinance provides that any person who assaults another person because of that person's religious expression commits a serious misdemeanor publishable by up to 6 months in jail. The city attorney filed a charge alleging that the officer had violated this ordinance by striking the driver with a rock because of the driver's religious beliefs and religious expression. The officer admitted that the driver's allegations were true and pleaded guilty to the charge filed by the city attorney. The municipal court sentenced the officer to 3 days in jail. After his conviction for violating the city ordinance, the officer was charged with 4 additional crimes. So these are the ones asked about in the call of the question. State B criminal charge. Claiming jurisdiction because a rock thrown by the officer struck the driver in state B. A prosecutor in state B has charged the officer with violating state B's hate crime statute, which, like the city's ordinance, provides for the punishment of any person who assaults another person because of that person's religious expression. This conduct is a felony punishable by 1 to 2 years in prison. So city is in state A, this is state B. So no double jeopardy violation there because of the sovereignty rule. State A criminal charges. A prosecutor in state A has charged the officer with 2 different state level offenses. First, the officer is charged with violating state A's hate crime statute, which provides that any person who assaults another person because of that person's religious expression and thereby causes injury to that person commits a felony punishable by 1 to 5 years in prison. Second, the officer is charged with violating a state A assault statute that provides that any person who assaults another person with intent to cause injury is guilty of a felony punishable by not more than 2 years in prison. So this requires a lot of statutory deconstruction, which is a bit of a difficult thing to do, but is something you have to get familiar with. And we talk about this in the Mastering the PT class. I definitely talk about it in that class. I think I'm talking about it in the next class that I'm teaching next week. All right, and then the federal criminal charge. So there's 4 charges here. We have the state B criminal, we have 2 state A criminal charges, and we have a federal criminal charge. So the U.S. Attorney for the Federal District of State A has filed a criminal charge against the officer, alleging that the officer violated a federal statute that makes it unlawful for any person acting under color of state or local law to assault another person because of that person's religious expression. The federal crime is punishable by a term of imprisonment of not more than 2 years. So here, this is a different jurisdiction, right? So the federal criminal charge, it's a different sovereign, that's going to be okay. There's some issue, though, with the state A criminal charges. State B prosecution is not barred despite the conviction on the city criminal charge because state B is a separate sovereign from state A where the prior prosecution occurred. And then is the federal hate crime prosecution barred by double jeopardy? It's not barred because it's a separate sovereignty. State A is separate from the federal government. These first 2 are pretty straightforward. This is also why you need to learn how to plan out your answer, because you need to know that like 1 and 2 are straightforward and 3 and 4 is where the points are. They require a bit more analysis. So this is triaging. We talk about this in the Mastering the Bar Essays courses, and that class is still just kind of getting going. So there's a couple that have occurred, but if managing your time is something you struggle with, I would definitely encourage you to check out that class because it's a major skill. It's something that you need to really kind of master to be able to pass this exam. So there's the link for that, again, just so you all have it. So is the state A hate crime prosecution barred by double jeopardy? So the city ordinance and the state A hate crime statute are prosecuting the same offense. The elements are the same. So the state A hate crime statute has an extra element, but it's still the same conduct because every element from the city ordinance violation is included in the hate crime prosecution. So if you look at this, so the city, any person who assaults another person because of that person's religious expression, that's the city criminal charge. And here, any person who assaults another person because of that person's religious expression, right? That's what it's prosecuting. Here we have an extra element, thereby causes injury to that person. Doesn't matter because the city criminal charge is subsumed in the state A charge. So they are identical. So the city charge is a lesser included offense. So it's definitely barred. Yeah, Bobby, good. Is a state A assault prosecution barred by double jeopardy? So this is different. So you need to explain it's not barred because each crime has an element which is not in the other. So state A assault requires proof that the officer acted with intent to cause injury, and the city ordinance requires proof that the assault was tied to the victim's religious expression. So this is really getting at all of the intricacies of double jeopardy. So I thought that was tougher if you weren't as familiar with double jeopardy. Hopefully you got familiar with double jeopardy though, really through the MBEs because you wouldn't have seen it on the essays. All right, so now here's this decedent's estates essay. So this is a really broad call. So how should the assets of testator's estate be distributed? It says, and they've adopted the Uniform Probate Code, pretty standard. So let's walk through this. So on September 4th, 2010, testator, who had 2 living children, George and Harriet, properly executed a valid will. The will contained only these dispositive provisions. I give my 200 shares of ABC Corp common stock, which I inherited from my grandfather, to my cousin Donna. I give my home to my brother Edward. I give my grand piano to my sister Faye, and I direct that all my just debts be paid before distributing the foregoing devises. None of the devises were subject to a survivorship contingency. The will contained no residuary clause. So you have to figure out, what do we do when there's a residue and there's no residuary clause? It goes via intestacy. In 2012, ABC Corp distributed 100 shares of its common stock to testator as a stock dividend. So this obviously gets tied to the provision to Donna. So Donna's going to want this extra 100 shares. So the question is, does she get them? Is she entitled to them, or does it go to the residue? And she actually does get them. In 2015, testator borrowed $125,000 to make home renovations. The 20-year loan was secured by a mortgage on testator's home. Testator was personally liable on the debt. So here, the question is the home subject to the mortgage? And even though it says I direct that all my debts be paid, it doesn't matter if you say I direct all my debts be paid, the home is still subject to the mortgage. It's subject to, so that means if it's not paid, it's subject to foreclosure of the estate. Edward is not personally liable on it, though. In 2020, testator gave $30,000 to her son, George. And in 2022, Faye, the named beneficiary of the piano in the will, died intestate, leaving testator and Edward as her only heirs. Yeah, testator and Edward. So Edward is the testator's brother. So Faye, this means that there's a gift that probably lapses. Because if somebody predeceases a testator, their gift lapses unless you have an anti-lapse clause. But if there's an anti-lapse clause, it has to go to your issue. But Faye doesn't have any issue because her only heirs were testator and her uncle, so she doesn't have any issue that any people that are come from her. 3 months before testator died in 2023, her grand piano was substantially damaged. She filed a $10,000 casualty loss claim with her insurer for the damage, and the insurer approved the claim. So the question is, does the piano go to Faye? And the answer is no. She gets the piano. And also Faye doesn't get anything because her devise lapsed. The insurer had not made any payment on the claim at the time of testator's death, and the damaged piano remained in testator's home. The insurer agrees that testator's estate is entitled to $10,000 on testator's claim. 2 months before her death, testator wrote George a letter informing him that the $30,000 she had given him in 2020 was intended as an advancement that would reduce any share of my estate to which you might be entitled. But for it to be an advancement at the time, it has to be, you have to make that statement at the time. And she didn't. And George, so we have George here. A month before testator died, George died, survived by his only child, Isaac. So Isaac is the issue of George. So there's also a bit of a wrinkle with when there is an advancement, there's a little bit of a wrinkle with that too that I'm going to get into in a minute. So testator is survived by 4 relatives: her cousin Donna, her brother Edward, her daughter Harriet, and her grandson Isaac, George's son. Testator's estate consists of 300 shares of ABC common stock, the 200 shares she inherited, and the 100 shares she received as a stock dividend, her home, her piano, $200,000 in cash, and the $10,000 owed by the insurer. Testator's only debt at her death was the mortgage loan on the home. Faye's estate is still in administration. Her estate's debts are greater than its current assets, and Faye's personal representative is seeking to recover the piano and the insurance proceeds payable to testator's estate. Not going to happen, Faye. So is Donna entitled to the 100 shares T received as dividends, plus the shares of the ABC common stock? So yeah, there's a rule here that I don't know I've seen tested before. I'm trying to reflect. But the devise was of the 200 shares, and if a testator specifically devised securities owned at the time the will was executed to named beneficiaries and subsequently acquires additional shares as a dividend, or it could be as a stock split. Here it was a dividend. Tina, I'm going to get to that. Then the additional shares also pass to the named beneficiary. So the fact that this was a dividend is critical. Then does E take subject to the mortgage? So if there's a specific devise that it passes subject to any mortgage despite any directive in the will to pay the debts. So E does take subject to the mortgage. And then is F's estate entitled to the substantially damaged piano and the 10K? No. So Faye predeceased T, so her interest lapse unless she was survived by issue, but she died without any surviving issue. And there's no anti-lapse here. Even if there was a statute, it still requires there to be issue. So Faye's estate is entitled to nothing. Who gets the residue? Because now we have the piano, we have the 10K, and we have $200,000 in cash. So there's no residuary clause. It passes through intestacy, and T's heirs are Harriet and Isaac. So Isaac and Harriet are going to collect via intestacy. They're each entitled to half. So the damaged piano, the $200K in cash, and the 10K casualty insurance proceeds. But does the $30,000 that T gave George reduce Isaac's share? So if there's an advancement, it must be declared in a contemporaneous writing that the gift is an advancement. And an heir must be an heir at the time of the donor of the gift died. So there wasn't a writing at the time stating that the 30K was an advancement. It came later. And George was not an heir at the time of T's death because George predeceased the testator. So this is testing just like a really tiny little narrow rule. I would expect a ton of people to totally botch that last part, that last point. Somebody asked, why does Isaac get anything? Isaac gets anything because he's George's issue. So he gets to inherit via intestacy. And that's why he gets to collect, because there is a residue and the residue wasn't called for in the estate. Somebody asked me in the Q&A, how many words should a passing MEE essay be? There's not really like a cut and dry answer. I think, I've seen some really good ones that are 400, 500 words. Mine tend to be closer to 700 words. So I would say like passing, and it just depends on how well you write, to be honest. That's why it's a hard thing to answer, but I would say if you're writing at least, 400, 500 words, that should be pretty solid. And make sure that the majority of that is analysis and use of the facts. Simple, clean rules, analysis and use of the facts. And yeah, I'll go to the past slide. All right, and then we're going to talk about the PTs in a minute. And I can't put the actual PTs up on the slide because they're protected by licensing, but I'm just going to talk through them. And as a reminder, I'm going to do a PT workshop. I'm going to go over some PT stuff in a few weeks. I don't think I figured out the date exactly yet, but we are going to do that. So be on the lookout. Make sure you're signed up to get notified of any of the free workshops that we are doing. We also just launched a YouTube membership where we're posting some exclusive content there. So you can find us on YouTube and it's pretty cheap. So definitely check that out. And yeah, this recording will be posted to YouTube as well. And it'll be posted in our free workshop in the bar exam strategies as well. All right, so let's talk about the two PTs. Pretty standard, pretty standard. I'll answer that question in a second too, the anonymous attendee asked. So State of Franklin v. Logan, this was PT1. It's an objective memo. It was tough because there was no organization given. There was two charges that there were, so you would organize by the charges and you had to analyze them. They told you to not do a statement of facts. I always say do not do statement of facts unless you are expressly instructed to do so. So unless you're expressly instructed to do so. So this is what my analysis would have essentially looked like. So there was two charges, robbery and felony murder. The robbery was pretty straightforward. This is another thing where you have to really learn how to manage your time, because this happens all the time where the second issue or a later issue is bigger than the first. You really have to learn how to pull apart a PT to deconstruct it in order to answer it adequately. This is something I really focus on in the MPT class and in the Cal PT class too. This is from the February 2024 PT. This is the one that was just given. And then there was felony murder. And this is what you needed to break down. There were issues in this. So did the death occur during the felony? Yes, you wanted to use both Clark and Lowry. Was there proximate cause? This is a tough issue here. Maybe, but it was a close call, and you would compare it to Finch. And then looking at superseding causes, and there were two potential superseding causes here. There was a malfunctioning traffic light and the fact that Stewart was not wearing a seatbelt. So you should go through your PT and look at that. Did you address these issues? And did you properly allocate your time? Did you spend a ton of time on the robbery and not enough time talking about felony murder? And then PT2, this is Randall v. Bristol County. And if you really properly allocated your time, then you're probably lacking in the analysis. I would definitely, if you want to see like what's going on, a couple of things you should do I'm going to talk about, but other than the PT class, I do have my MPT book coming out. It will be out sometime this month. It keeps getting pushed back, but it will be coming out with plenty of time for you to study and prep for the July bar. PTs are totally learnable. You just have to know exactly how to do them. I love the PT. So definitely check out all of our PT resources, including, I'm doing these things called bar essay checkups. They're the next 6 Sundays. I've already done one where I provide you all of the materials. It's proctored and you're going to go to work. You're going to do the 3 hours of work, and then you stick around and I will explain and walk you through what you should have done on the PT, and you will also get my answer to compare yours to. So the second PT, so the first one was objective. The second one was a persuasive argument for a brief. The organization was not given again, which makes the PT a little bit tougher to do. And you need to know what to do when they don't tell you how to organize in the task memo. I always think that makes the PT a little bit more challenging. Still totally figure outable. You just need to know what to do. So there is also a format memo, and it specifies how to write your headings. This is really standard. When you're given a format memo, this is often one of the things that you're told how to do. And they also say to not do a statement of facts. So here, you did the argument section. So this is a public employee entitled to First Amendment protection. So here you had to address, were they speaking as a citizen? And there was 3 cases you could use, Garcetti, Lane, and Smith. And then was it on a matter of public concern? Here we use Garcetti, Dunn, and Smith. And then were you balancing the employee's interests against the employer's interests? So here again, Garcetti, Dunn, and Smith. So look at the cases. What did you do? If you're not happy with your score, then it's probably like you're not doing enough comparison. The PT, the hallmark of it, is comparing the facts of our case to the facts of the cases in the library to explain why a particular outcome is warranted. So that is really key. And if that's something you have a hard time with, you should definitely reach out, because that's something, I think that's really what I'm known for. Like my YouTube videos on PTs have a ton of views. And that's like, I don't know, it's probably how a lot of people have found out about me, is through the PT. I like to really break it down and make it very, very simple. All right. So for joining us today, you're going to get an email. It's going to have a sample of my MEE book. So be on the lookout for that. Somebody asked me if I have any advice on how you should balance studying the MEE only subjects between the MBE. Honestly, they love testing those MEE subjects. So, doing as much practice as possible, really seeing as many essays as possible, that is really key, and doing a ton of practice. So I'll put the link. This is the bundle for if you want to do all of the bar exam checkups. We did the first one, but it's recorded and you can definitely still join and you can watch it. And this is where it's $25 per session, and they're long sessions where it's proctored. I'm proctoring it, then I'm reviewing everything with you. This is different from the classes. The classes we are teaching the whole time. We're showing you how to do everything. And in the actual, in the checkups, you guys are doing the practice, and we're just running through the issues and the facts, what you need to talk about. Going more into detail than I did tonight. Definitely going into more detail. Laura, can you send me an email about that? And the bar essay checkups are for both California and UBE. I do a different breakdown for each. I do UBE first. So we do 3 hours of practice, take a little break. Then I go over the UBE issues. Then I go over the California issues. All right, everybody. Thank you so much for joining me. We'll send you an email that has the links to everything. And yeah, California PT is really good to watch for UBE folks. I also have MPT stuff, but yes, absolutely. They're the same, essentially. So they're the same. I hope to see you all in the classes. I hope to see you enjoying the books. And if you all need anything, please feel free to reach out to us and let us know if you need anything. Thanks, everybody. Thank you so much. And to the question about spelling isn't a huge deal. It's the same as the MEE. It's not a big deal. All right. Have a good night. Thanks, everybody. Bye.